Good morning. This is Jean Eaton, your practical privacy coach and practice management mentor with Information Managers. Now, just a reminder, I'm not a lawyer and I don't play one on TV. These are my recommendations based on my experience and research and not legal advice. How to prepare patient records for a court order. So this was a question that was brought in by a member who received a court order to produce patient records in the court. I know that receiving a court order to produce patient records can be scary. As a director of health records in hospitals across Canada, I have frequently received court orders or subpoenas to produce patient records in a court of law, tribunal, or coroner's inquest. I have also worked as an independent court reporter and have attended hundreds of legal proceedings, including criminal and civil trials, discoveries, and inquests. When you are prepared with policies, procedures, and a little bit of training, you can deal with these stressful situations with calm and confidence. So what typically happens in these situations is that you are at work at the clinic and you have somebody come into the clinic, and often it's a police officer. The first thing about that we typically tend to do is to panic, but I don't want you to do that. So don't panic. When you have a police officer standing in front of you and they've got a court order, or it might be a lawyer, or perhaps it is a member of the public that's presenting to you the court order, don't panic. Typically, you have time to prepare and respond to this information, and you're going to do just that. Now, what you're going to want to do is review the information with the person right there and clarify the details with the person right there in front of you. Who is this person? So this is where you get to start taking notes. What is it that they want? Usually they want court patient records to be presented in court. So this does not mean that you start preparing the records now and give it to the person before they leave. What it means is that you are reviewing the court order, you're recording the date and the time and when you received it, who brought it to you, and be really clear about the patient details. So while the person is sitting there in front of you, you ask them about the details about the patient. Make sure that you've got a full name and date of birth and perhaps a healthcare number to be able to properly identify this patient and see if you actually have this patient as part of your practice and that you have those patient records. What time period of records are they looking for? Is it something that's current, or is it something that's 20 years old and you don't have anymore? And who is presenting the information? So where do you actually have to present the information in the court? Is it Alberta court? Is it a federal court? Is it some disciplinary hearing? What is the legal body that is requesting this information and that you will have to respond to? And is there a phone number that you can contact this person when you have additional questions and that you want to be able to verify the information? You want to read this document really carefully. So I want you to be really clear about what this isn't. This is not a routine request from the patient to access their records. This is a court order where you prepare the patient records and you present it to a court or a tribunal or a coroner's inquest or something like that. You do not give the records to the patient. You do not give the records directly to the lawyer. You are required to appear in court and present the records in the court. Okay? So if you are presenting the records in the court, you don't need the patient's signed consent. This is an exception to the general rule about a patient can have access to the records when they have consent. And that still applies, but this is not that. So if the patient wants to have access to the records, or the lawyers want to have access to the records and provide you a patient's consent to be able to release the information to the lawyer, that's great, but this is not the court order process. What this is that you are required to prepare the patient records and present those records in a court of law to present them for their purposes. Now, this typically is not a situation where there is a complaint against your clinic or your providers. This isn't a malpractice situation. This isn't a complaint about a criminal activity that your staff or your providers have done. This is that somebody wants to have access to these patient records to produce for a criminal or a civil proceeding that is not directly related to the care that you've provided to the patient. If you are presented in a situation where there is a requirement to prepare records for a malpractice or a criminal offense with your staff or your providers, you're going to also want to contact your lawyers. But if this is for a third-party purpose, somebody wants to have access to those patient records to present in court as evidence for a civil suit. It might be a divorce proceeding. It might be a fraud case for medical fraud or an insurance or identity theft. Then this is how you're going to prepare those records. Okay, so if you've got any questions about what this is or isn't, enter them in the chat and we'll talk about that. So you're going to review this document very carefully. Be really clear about what court is requesting this information, and then validate the request at the court. So there should be some type of contact information on that court order, and it might be the clerk of the court, it might be the witness coordinator. Phone and contact that individual on that court order to confirm that yes, it is a valid court request. Make sure that you've got the file number for the court, confirm the date and the time that you are required to attend, and confirm that you have received this information. So you've received that court order. So make sure you've got all of that information right away. Then the next thing you're going to do is make sure that you have the patient records. So you're going to want to do this rather quickly. If there's some extra reason why these patient records are spicy, you want to make sure that you have contained all of the patient information and make sure that it's not available to the average person at your clinic. So you want to make sure that you can locate the information. Make sure that you are looking up and you've received all of that patient's information. So if it's the patient's name is Jane Brown, make sure that you've reviewed all of the Jane Browns in your computer system and you've identified the ones that are responsible, that you would respond to this court order. That's why you want to make sure that you know the name of the contact person, because you might have more than one Jane Brown in your patient's record. You want to make sure that you're accessing the correct one. Make sure that there are no duplicate records or records that might be in a shadow system. So some clinics, for example, when they see the patient only once, they'll have a paper record and they don't create an electronic record. Make sure that you've got all of those paper and electronic records for your patient. So you're going to start making notes for yourself about what you did, because you may have to present a testimony in the court about what you did to make sure that you've got all of the patient records. So note the date and the time of the information, that you did an electronic medical record search, you identified these patients, you confirmed that this is the correct patient, and so on. Now you're going to read those patient records really carefully and make sure that the record is complete. So if your healthcare provider sent this patient for lab tests, make sure that you have all of the lab test results as part of that patient record. Make sure that you've got the preliminary results and the final results. If they were sent for a consultation to a specialist, make sure that you've got that specialist report. So make sure that you also grab the audit log for this patient record. Make sure that you know who has accessed the records of this patient, when did those records get received, were any records deleted or canceled in error. Make sure that you've got a comprehensive document about all of the information for this patient's care. Now, this is the point where you're going to review with a fine-tooth comb about who was involved in the patient's care. So who's the patient's most responsible custodian, their healthcare provider, whether that's a physician, a dentist, chiropractor, pharmacist. Make sure that you have identified all of those individuals and that you have informed them that you have received a court order. So the physicians or the custodians, if they're currently in your practice, can have the opportunity to review that patient's information after you've made sure that you've got all of that information and that record is closed, so that they can review their notes, because they want to be aware about what's happening about that patient information. If that physician or custodian is no longer part of your practice, do your reasonable best practices to make sure that you can contact that physician at their new location, let them know that you've received a court order and what the steps are. So you're going to make sure that you've informed your custodian and your privacy officer, and make sure that you make those notations in your chronological listing of all the things that you're doing about processing for that court order. You might want to contact your lawyer or your CMPA representative. And if this is the first time that you've done something like this, you might want to do it. If you're working in an organization where you regularly receive court orders, you may not need to contact your legal representative if it is not an issue about the type of care or the services that the patient received at your practice. If it's entirely for third-party purposes, you may not have a need to contact your legal representative. I'll leave that for you as a decision to do. Now that you have reviewed your patient records to make sure that it's complete, you're going to start what we call the fine art of severing. Now, severing, also known as redacting or blacklining, is looking through the information line by line and identify any information that is not appropriate to include in the disclosure in the court record. So you may go through those informations and find out that the physician reported that the patient had an argument with their employer that day, and that's the reason why they were coming for their appointment. So you may take out the names that they mentioned, the employer's name, the name of the boss, or that there was some type of a conversation that the patient had, even disclosing their family medical history. You can identify that there was a family medical history of XYZ syndrome, but take out the name of their mother or their aunt where that XYZ syndrome it relates to. So you're going to take out names of individuals that are not directly related to the care and treatment that the patient received in your facility. Now, you're going to redact it or blackline it, and then you're going to make a notation to say, this is number one, and the reason why you did not include the information in the patient record that you're going to present to the court. So there has to be a legal authority to take that information out. So you're going to provide a cross-reference between all of the information in the document that you are removing, and in a separate document, you're going to identify why you have the legal authority to remove that information from the document. So the next step is to create kind of a table of contents so that you can review the information very quickly about what is included in that patient record. And it might be very simple. It includes the visit date, the description, and the page number in that patient record that you've included. So as you prepare all of the documents together, you're going to prepare a paper record. So you're going to print out all of the information and you're going to put it in some type of order. Maybe it's chronological order by date or the type of information. So all the clinic notes go together, all the lab reports go together. You can decide how you're going to print it out and organize it. At the bottom of each page, once you've got it all organized, you are going to handwrite the page number so that you could quickly refer to a particular page when you present at court to say the patient had a visit with the doctor on January 1st, and it's on page 5 of the documents that you've presented in the court. So you want to sequentially note the page numbers, and you can handwrite this on the bottom corner or the top page number of the documents that you've printed out. Now make sure that you're going to stamp copy on each page. And then you're going to complete your table of contents. So now that you've got your page numbers done, you'll do your table of contents. It's a bit of a back and forth to make sure that you've got each of that information. Now you're going to make a photocopy of this document. So whether or not you created the document first, if the patient record was first in paper records, you're going to make a photocopy of it and then stamp copy. If it was in an electronic format, you're going to print that electronic information into a paper format, put the page numbers on it, and stamp copy on each page. Once you've got that complete package done, this will be one of the very last things that you're going to do in preparing this package. You're going to make a photocopy of the paper package so that when you get to court, you're going to give them your new original set of documents, and you're going to ask the court to accept a copy or photocopy of those original documents. So you don't want to get to court and find out that the court is going to take both of your copies and take them to the court. So you don't want to lose track of your original document. So you can keep your original document at the clinic. You might bring it to the court with you to be able to say that here's my original paper copy. We want to keep this as part of our clinic records for continuing care and treatment, and ask the court to accept a true copy of that photocopy package. I hope that's clear. Then when you actually, the other thing is that if you are sharing the information from an electronic system, make sure that you have all of the information that you need to provide in your testimony to say, this is how we routinely create our patient records. We use an electronic system. It is called XYZ, and we use version number 1234. And that you retrieved all of the information from the electronic system on such and such a date. Now, you might also print out a hard copy of the audit log so that you can identify when those original documents or those original notations were made in that patient record and who they were made by, and any deleting or errors about that information, and whether or not that information was disclosed to anybody else and on which dates that you disclosed it. So when you get to court, the day before, you're going to contact the clerk of the court again and make sure that you are required to be there as a witness. So these things often change. These dates often change. So you can't ignore the court order. You must attend if you are compelled to attend and provide testimony. But know that the date and time for these things changes regularly. So you're going to make sure that you attend the court at the time that you need to be there. You're going to report into the clerk of the court and say that you are from such and such a clinic and that you're here to provide testimony with the court order. So make sure that you bring your original version of that court order document with you. Make sure that you have your own photo ID because you'll need that to get into the court and to actually provide testimony. When you get to the court, it would not be unusual if you find out that your date has been postponed or the proceedings have been canceled. It would not be unusual that you get to the court and find out that you might have to cool your heels for 5 hours in the hallway before you actually get called to provide testimony. So bring a good book with you. You want to be prepared to share this information with the court. Now, when your turn to provide testimony is coming to the court, you are going to be asked to affirm or to swear in that you're going to provide a true testimony. So be prepared to do that. And you are going to be asked questions about where do you work and how are the patient records created. So it is not the expectation, and you should not be interpreting what those clinic notes are. So if the doctor has written RO, rule out pneumonia, then you can provide some interpretation about what those standard abbreviations are, but you cannot provide an interpretation, unless you are a doctor, about what does it mean that they're going to rule out pneumonia. All you can provide is, this is what the abbreviation means, and this is the word pneumonia, and it is not your role to provide clinical interpretation about what happened to that patient. Your role is to say, this is how our patient records are created, this is how they're maintained, this is how I know that this is a complete patient record because I did these searches on these days, and this is how I know who created the notation in the patient record because I can either match their handwritten signature, or you've got an audit log that cross references to a user listing, so you know exactly which user was entering that clinic note according to the audit log in the computer. So you are going to provide the copy of the patient records to the court, and oftentimes your time as a testimony is really very short. It may be 5 minutes, it may be half an hour. It probably isn't more than that. Based on my experience of going to court as a director of health records in a variety of hospitals, and actually I've been a court reporter, so I've got some experience about providing the information to the court. So when you get to the court, you may be required to leave those copies of the records with the court, and make sure that you make a notation in your records that you did that and to whom you release the information to in the court. So actually get the name of the person that you handed the documents over to. It might be the lawyer, it might be a legal assistant, it might be the clerk of the court. So make sure that you get the names so that you can document in the patient records that that's what you've done. So when you return to the clinic, you're going to write a short summary of the day. Did you provide a copy of the patient records? To whom? Make sure that you've got a file number for the court so that you can follow up in 6 months to a year to make sure that you know what the status of that court proceeding is. The chronological listing of all of the things that you've done for that patient record as part of your business records for the clinic. So that chronological listing of all the things that you did to prepare the records becomes part of that business record. So you want to know when you can close that file and whether or not there's any outcome that you should be aware of in managing that patient records. When you return to the clinic, review what happened. What did you get surprised about? What happened that you didn't expect? Can you update your policies and procedures? And you may find that you need to submit an invoice or a bill for expenses to your employer for the time that you spent, for the parking that you paid, for the lunch that you bought, and you may get a witness fee from the court, so you need to provide that to your employer as well, so that your employer can identify, what is the salary that you're going to get for that day or two to be able to provide testimony to the court. So those are the big steps about your procedure, about receiving a court order, how you are going to prepare that record, how you actually what to expect when you arrive in the court to provide your testimony. So here are the things that I suggest that you need to do now to prepare for a court order. So there is a download practice management success tip about how to prepare patient records for a court order. It includes a summary of things that you need to review in your current policies and procedures to make sure that your policies and procedures identify those things that you need to do as far as a court order. Now, I've also given you a template procedure about how to prepare records for a court order. So go into your practice management success Q&A lesson, and then you can download the template of the procedure and the ebook about how to prepare court records for a court order for your patient records. So you can download the ebook, How to Prepare a Patient Record for a Court Order, and then in that ebook provides you with some templates about a procedure that you can upload into your policy and procedure manual so that you have the documentation in your policy and procedure manual. So let me know if you have any questions about this process. You can enter your questions in the discussion in the practice management success tip in this lesson, and let me know how this has been of use to you. Let me know if you have ever attended a court order. Have you provided testimony in a court? and how your experience may have differed from the way that I've explained it in this video. This is Jean Eaton, your practice management mentor and practical privacy coach. If you like this episode, please subscribe to this channel and add your honest feedback to the comments below, so that people who like what you like can find this podcast.